we've had these tremendous panels, and it's just been great so far. And I was just telling Professor Holman that this is really nice. The patent academic community is great, and that I feel like I know all of these people through their writings, and we really are a group of colleagues, which is just fun. And in fact, the patent law community is relatively small, especially when you think of the number of folks who are kind of actively engaged in thinking about policy and somehow writing about it and talking about it. Right after a few years in this business, you end up getting to know most folks. And so thank you for coming today and being part of that. I'll introduce these guys really quick. Our first speaker is closest to me is Professor Christopher Holman. Professor Holman is Associate Professor at the University of Missouri, Kansas City. And so we're colleagues, and then we're both employed by the state. He teaches intellectual property classes, and with a real focus on biotechnology and biotechnology law. Professor Holman worked for a number of years as in-house counsel out in Silicon Valley, and he's got a very strong technical background in chemistry, and has been doing interesting work on kind of personalized medicines and how that should fit in relation to law. Now, you may also know Chris because he has Holman's Biotech blog, which if you are not familiar with it, and if you are at all interested in biotechnology and law, it's a fabulous resource, and he writes in a way that's clear, easy to understand, but also compelling and informative. And so I would direct you towards that if you have time. Sitting next to him is Jason Mudd, right? So Jason is a practicing attorney. He's our second non-law professor, right? Him and Capos, so he's in good company at least. He works at the law firm of Schuckarty-Bacon in Kansas City, and he's kind of one of the rising stars of the legal community in Kansas City. He's a graduate of Mizzou Law, and I graduated a couple of years before I started here, but from my first week on the job, I heard his name because everyone was whispering about whether the Mudd outlines would work for my property law class. Just yesterday, a student on law review told me that half of the students she believed passed. I don't know, for those of you who know Professor Carl Esbeck, he was one of our strictest and most difficult constitutional law scholars and professors. She believes that at least half of the students in that class passed because of the Mudd outline, whose copyright has been extensively infringed upon. And I was even talking last night with Professor Tom Lambert, who's our antitrust professor here, who during each class, at a certain point in the class, he knows to pause for a moment to say, and for those of you reading the Mudd outline as I'm talking, there's an error. And correct this line. And so he continues to reverberate, his name continues to reverberate through the law school. And we're very happy to have him here today, especially to present his, right? Most of the professors have some practical experience, but his is a little more current than most of the rest of ours. The furthest away from me is Professor Greg Vetter, who is also known in these parts. Professor Vetter grew up in Jefferson City. He went to the University of Missouri-Rolla, which is now has changed its name, as a lot of campuses have. He also attended. He also got a master's degree from UMKC as well as Rockford College in Kansas City. Right, so there's lots of interesting facts about Professor Vetter. He was the captain of his wrestling team, and so if we right, so I'm still going to ask you tough questions. So he stays he's associate professor of law at University of Houston in Houston, and his work, right? So Professor Holman really focuses on biotech, and Professor Vetter's focus is on software, and with a special focus on open source technology and thinking about how open source and patent law interrelate. And there's lots of interesting issues in these articles that he's wrote. written, and I think we're going to follow the same pattern as we have in the prior panels, where each of these guys are going to give a short presentation, and we'll have time for question and answer at the end. And if you don't get your question in, you can find them at the cocktail hour as well. Chris? Okay.
Yeah, today I'm going to talk about the effect of this around the federal circuit and elsewhere on pharmaceutical innovation. That's my background. Before I went to law school, I worked at Roche Biosciences in Palo Alto in drug discovery research. And I think it's been conventional wisdom within that the industry for many years that this is something that's really dying out. There's not much future. There's not many medicinal chemists who are recommending young people to go into the field because it's perceived to be not much of a future, at least in the United States. And I think here's some statistics from the first half of 2010, estimated 9,000 pharmaceutical R&D jobs lost, including Roche in Palo Alto, the place that I worked. This is was Syntex. This is the birthplace of the birth control pill, of these things like this. It was shut down this year. Okay, the carnage continues. Pfizer, the world's largest drug maker, closed its research facility. It's also been conventional wisdom for a number of years that it's probably not a good investment to invest in pharmaceutical R&D for innovative new drugs. And here's some stuff from just this month. Morgan Stanley running the numbers, making it abundantly clear that internal drug discovery and early development is not a good investment. Here's something from Reuters making the same point, that we're kind of maybe in the last phases of this big investment in drug R&D. Decreased investment results in decreased output. We're seeing this. 2009 was about half the number of new molecular entities launched as there was 10 years earlier with those at its peak. What is the response of the Obama administration? They recently announced starting $1 billion drug development center at NIH. So basically, because of frustration on the part of people like Francis Collins, people in the federal government, that discoveries are not being translated into drugs, that they're going unexplored because the companies neither have the will nor the resources to develop these into drugs. The federal government is looking into doing this. How good are they going to be at this? The conventional wisdom also, I would say, is that NIH and public sector research is not good at developing drugs. They're good at the initial early stage discoveries, not so much as turning them into drugs. Professor Mark Lively, they're not good at drug discovery. Why are they doing this? I think the answer is frustration, if not desperation. Here's NIH Director Francis Collins, frustrated. 10, 15 years ago, the Human Genome Project, there was all this anticipation of all the drugs that were going to come out of it. It's not happening. Frustration. Now we're going to get NIH involved in trying to make drugs. Okay. Very nice conference I went to a few months ago at the University of Illinois. This one had Dr. Chakrabarty from the Dr. B. Chakrabarty decision. 30-year anniversary of the case. Dr. Chakrabarty gave a nice talk, and he attended through all the patent talks with his family. Really good guy. One of the first speakers was Robert Armitage. He's the Senior Vice President and General Counsel for Eli Lilly. And I pulled this off of his first PowerPoint slide. He said, uncertain, unpredictable patent enforceability will destroy the ability of pharmaceutical companies to make high-risk investments to make new medicines. So that's his point of view, is that unpredictability is the major culprit in patent law, and it's stopping investment. He cannot get the company to invest in taking these promising candidates through the drugs because he can't give them a good solid answer that there's going to be patent protection for them. Innovative pharmaceutical R&D is getting very increasingly expensive and risky. Here's some numbers just showing that these phase 3 terminations, so these are terminations of clinical trials after millions and millions of dollars have been spent, how much this is going up. And it translates, this study just came out a few days ago, 2004 to 2010, 7% of traditional small molecule chemical drugs made it through clinical trials and to FDA approval. And that's the small percent that actually get into humans. We're not talking about all the leads that don't make it that far. Cancer drugs, 4.7% success rate. Okay. In the interest of time, patents have played a critical role in providing the necessary incentive for innovation in pharmaceutical R&D. Hatch-Waxman provides a 5-year data exclusivity that precludes generic drug competition for a limited number of years, but that's not thought to be enough. In fact, the de facto term of market exclusivity before the generic goes on the market is typically about 11 to 13 years, and this additional time is due to patents. But as Professor Lemley and others have pointed out, patent protection is probabilistic. Probabilistic patents, probabilistic translates into unpredictability, uncertainty. Okay. Now, let's see. In order to get adequate investment, there needs to be a perception on the part of investors that they're going to have patents that they're going to hold up and provide this period of exclusivity. Under the current environment, we're seeing a repeated pattern of patents being invalidated in pharmaceuticals based on these gotchas. And typically what's happening is the Federal Circuit is changing or coming up with a new doctrine and applying it retroactively to patents and invalidating them based on decisions that were made 20, 30 years earlier. Okay, so thinking about unpredictability and uncertainty in the patent laws, I think of 3 different categories. The first category has been talked about quite a bit today, the use of standards versus bright line rules. Okay, that's fine. I think probably more damaging to the pharmaceutical industry and others are these other 2. One problem is delayed resolution of important and clearly identifiable ambiguities in patent law. For example, right now we're wondering, can you patent an isolated DNA sequence, isolated naturally occurring DNA? Gene patents, 30 years we've been having gene patents issued. And now we have, just months ago, the federal government saying, well, actually, we don't think they should have been patentable. What kind of system do we have where it's taken over 30 years and we haven't answered a very fundamental question? Can you isolate something like a polynucleotide? Is it going to be a patent-eligible subject matter? But I think even worse are these unanticipated and substantial changes in patent law that are being applied retroactively and in a manner that really destroys the investment-backed expectations of the inventors. So I thought it was worth maybe going through a case study or 2 and showing this is what, when Robert Armitage had this statement, he was stinging from some recent decisions where their Eli Lilly patents were invalidated. One of them, Gemzar. Gemcitabine, this I believe is the first and I think still only treatment for pancreatic cancer. Okay, a terrible disease. Okay, how did this come about? Well, early in the 1980s, Eli Lilly scientists succeeded in synthesizing a very challenging class of compounds. It was very difficult just to make these things, an invention in and of itself. Okay, but they succeeded. They tested and they found that this compound, gemcitabine, has antiviral activity. So based on this, in March 1983, they filed a patent application disclosing the compound and its antiviral activity. Okay. 8 months later, they hand the compound off to another scientist at Lilly, and he starts testing for anti-cancer activity. And lo and behold, they find significant anti-cancer activity. So 20 months after the original filing date, they filed a second application, this time disclosing and claiming use of gemcitabine for the treatment of cancer. Okay? But that's when Eli Lilly made their critical mistake that resulted in patent invalidation. What was their mistake? The mistake was, on the same day they filed this method of cancer treatment application, they refiled the composition of matter application as a CIP, adding a single paragraph disclosing the anti-cancer activity. Why did they do that? Who knows? But now we think maybe as an attempt to comply with the best known requirement. You got to put yourself here. This was more than 10 years before Transco. It was an open question. What was the requirement to update best known? And so probably out of an abundance of caution, they decided, okay, let's disclose this anti-cancer activity. We'll introduce that into the composition of matter patent. Okay. Okay. So that the first application directed to the composition of matter issued in 1989, and the Patent Office explicitly found that the antiviral activity disclosed was sufficient for utility. So in other words, the anti-cancer activity that they added later was totally unnecessary for patentability, patent eligibility, but they erred on the side of disclosure. Okay, so they ended up after extensions with a patent on May 15, 2010. Okay, the second patent application issued as a patent claiming gemcitabine as a treatment for cancer. Okay, that issued in 1995 should have expired as a typo. In 2012 should have expired. Okay, this is the one that's going to be invalidated. Okay, the drug Gemzar, it was initially approved in 1996 for treatment of cancer. Now things like pancreatic, metastatic breast cancer, these are the kind of applications this drug is used for. Okay, as inevitably happens, the generic drug challenge from some pharmaceuticals, the declaratory judgment action is filed. The end result is July 20th, 2010, the Federal Circuit affirms the decision from the District Court that the second patent is invalid for obviousness type double patent. Okay? Now, and that the petition for rehearing en banc was denied. It's currently on a petition for certiorari. Two important things you should pull out of this. I could spend an hour talking about obviousness type double patent. It's pretty intricate. But two things that should strike you. Number one, the second patent would not have been invalidated if they had not made the decision to add the disclosure of anti-cancer activity in the CIP. They didn't have to do it. It didn't help them at all. They did it because they weren't sure about the best mode requirement. But that solely was responsible for invalidating the second patent. The second point is, very clearly, if these two patents had been owned by different parties, the second patent would have been, they both would have been valid. It was only because they were commonly assigned that obviousness type 1 patenting was applied. And actually, another district court in Indiana specifically found, they treated this earlier patent application as 103 obviousness prior art and found it did not render the patent obvious. Now, if you look at the roots of obviousness type double patenting, it's a totally judge-made law. It comes from the Supreme Court decision in 1894. But what I'd point out from that decision, this was a divisional. What the Supreme Court explicitly found was that all the material claimed in the second patent, it was found to be obviousness type double patenting, could have been claimed in the first patent because it was all disclosed, it was the same specification. And the Supreme Court, basically, in the language of the day, said clearly this second patent would have been invalid if it wasn't for the fact that it was the same inventor. Okay? And so I think that's the justification for obviousness type double patenting. It's used in situations where, for various reasons, because it's the same inventor or commonly assigned, you can't use the earlier patent application as prior art. It doesn't seem applicable in this sort of situation. But what happened here is the Federal Circuit applied, this panel applied the Geneva decision in 2002, which basically found under those facts that if the earlier patent disclosed a method of using the compound, then a second patent directed toward that method of use is invalid for obvious type double patenting. The facts were very different. But what happened to Eli Lilly is in some pharmaceuticals, a different panel treated this as a bright line rule. Okay? That was a very bad idea. It was totally unjustified. Geneva was written by Judge Rader. And Judge Rader joined Judge Lurie and four of the judges on the Federal Circuit. And they said, no, this Sun Pharmaceuticals decision, it totally misunderstood Geneva. It was not meant to be a bright line rule. This is entirely inconsistent with all of our precedent for obvious type double patenting. But as it stands, what they did in a nutshell is they created a bright line rule for a judge-made, non-statutory basis for invalidating a patent and used it to invalidate a patent based on a decision made in prosecution 25 years earlier that was totally ministerial, the addition of this anti-cancer activity to the application. Okay. I have another, I thought maybe I was going to use this for like CLE, you might want this, so I made a long PowerPoint. So it's available to anybody who'd like it, I'll send it to them. But I have another good case, and I'm going to write this up for the guys here. Another good case study involves Shantara, where a similar type of thing happened. Okay, we'll try to finish up in 5 minutes, 20 minutes. Okay, so everybody knows that there's a lot of these ambiguous standards. And repeatedly, the Federal Circuit tries to create a bright line rule, and the Supreme Court has to say, no, we're going to replace it with a standard. The Federal Circuit, though, has probably quite a few vague standards themselves. Lily written description requirement, kind of pulled out of the blue, and as Judge Rader said, it's really, there is no criteria for satisfying it. It's just a wild card that a court can use to invalidate a claim it doesn't like. Enablement. Some people pretend like we know what the rules of enablement are for claim scope. Hey, we don't. And as Judge Lynn pointed out, the court has left unresolved the question of the extent to which enablement constrains the ability to claim known and unknown combinations. We just don't know, and he's correct. But I think, okay, I'm going to turn to a couple of the other types of ambiguities that I certainly think are a problem. Delayed clarification. I talked about the situation with gene patents. The best mode is another example. But new legal doctrines applied retrospectively. Okay, FESCO is an example of this. 2002, the Federal Circuit basically out of the blue makes a bright line rule that says that no longer is there doctrinal equivalence for any patent element that was amended during prosecution. And here's some language from the Supreme Court, where the Supreme Court rightly said, you can't do that to the investment-backed expectations of inventors. They amended their patent claims with the understanding that they weren't giving up doctrinal equivalence. So I think very correctly the Federal Circuit reversed on that. Okay, solutions. We've been listening today about the role of the Federal Circuit. I think there's a fundamental problem with the Federal Circuit making policy in that since they can't, they have to, in case of controversy, they are able to do it in a way that takes into account investment-backed expectations. Because really what you want to do is if you're going to change the law, change it prospectively. Don't do it in a retroactive manner. So I'm suggesting maybe the PTO and Congress should have more of a role. They're in a better position a lot of times to weigh the policy considerations. You look at the PTO, Chakrabarty. Very early on, there was a question, can you patent a living organism? Right? Because the Patent Office rejected it and set it up in a way that was appealed to the Supreme Court, we got early resolution of that one. You look at the failed continuation rules. Nobody liked those, but at least there was some attempt not to apply them retroactively, at least in some contexts. So there was some respect for investment-backed expectations. We got early judicial review of it, and I think that part of the problem with those rules is the PTO was attempting to make a substantive move. I think they were attempting to address the real policy. There is a real issue with late claiming. There is an issue when you're filing an application and waiting 15, 20 years and adding new claims. And I think they were trying to get at that, but because they have no substantive rulemaking authority, they tried to finesse it into some kind of procedural by using these discontinuation rules, which were a very poor and very indirect attempt at trying to get at really what the issue is, which is late claiming. Maybe if they had substantive authority, they would do a better job. Because I know a lot of people would say, well, after those continuation rules, we don't want the PTO making policy. But maybe if that was their job, maybe they would do a better job. And then Congress. This Sarah bill that would have banned the patent of DNA, it was a terrible idea, but at least it would have only applied prospectively. It would not have applied to patents issued before the date of it. And we see this over and over when Congress changes the law. They do it in a manner that is applied prospectively, not retroactively. These are examples. Let me finish up with an example here. 287C, this is it's not invoked, but we have this exemption that there is no liability for doctors and hospitals if they're conducting a medical activity. There's some kind of infringement in the course of the medical activity. What happened there is some doctor got a patent on a method of surgery, I think, and there was this uproar, whoa, maybe doctors are going to be sued. Okay, Congress nipped it in the bud because they just said, okay, we're not going to ban patenting these things, but if you're concerned about doctors being sued, we'll just say there's no remedy. They can be sued, but there could be an indirect infringement, by a company making the devices, but we're not going to, we'll just nip that one in the bud. And so right now we have these people saying, well, with gene patents, a doctor could be sued for talking to their patient or for thinking about a correlation. Okay, if we're really concerned with that, Congress could get in and just say there's no liability for a doctor thinking about something or for communicating with a patient. You don't need to go down the road of trying to invalidate all gene patents when in fact they're the foundation for an industry of field that invests billions of dollars based on the idea that these are actually patents. Okay? And then finally, maybe for pharmaceuticals at least, we should even be thinking about getting away from relying solely on patents. For the biologics or the biosimilars, There's a 12-year data exclusivity period, which Obama, I guess, is now trying to cut back to 7. But they have this extended period of data exclusivity. Under the Orphan Drug Act, if you make an orphan drug, you have market exclusivity. You're the only one allowed to sell that drug, irregardless of any patents, because you've brought to market a drug that's treating an orphan indication. And unless somebody comes up with a different, better drug, nobody can compete with you. And so maybe we should be thinking about that instead of the situation we have today where probably a lot of good drug candidates are just not being developed because of the uncertainty and unpredictability as to whether they're going to have patents. Okay? All right, thank you.
Good afternoon. Today I'm really going to be making a series of observations about the line between where claim construction stops and the factual question of infringement or validity begins. As Professor Bunnell has said, when imprecise language can be left to the jury remains a subtle, confounding, and thorny aspect of patent adjudication. Frequently in patent lawsuits, we are bickering about the meaning of singular, ordinary English words and what impact that has on the infringement inquiry. But the question is, well, first let me tell you, let me go through an overview of where I'm going to be going. First, I'm going to start with the basic background and legal framework of current claim construction. Then I'm going to talk about the processes we use in litigation, in district court, and in the International Trade Commission to perform the process of claim construction. Next, I'm going to talk about the Federal Circuit's decision in O2 Micro. It was a 2008 decision where the Federal Circuit found it was an error to submit the meaning of the terms only if to the jury as a sending a question of law of claim construction to the jury in violation of Markman. Now looking at examples of how courts are following O2 Micro's guidance and how litigants are using O2 Micro as, in effect, a hammer instruction to district judges telling them to comply with Markman's mandate to resolve disputes and provide the certainty that Markman promises by not merely punting on the issue of claim construction by determining that no construction is necessary. As Judge Richard famously said, the name of the game is the claim. As Professor Lemley mentioned, we are obsessed with claims today. The modern system is one of peripheral claiming where we are obsessed over using language and pushing it to its very limit to resolve disputes as questions of law. And we often think that claims are, in essence, real property that can have finite and definite boundaries that are fixed and can be fixed with precision. But in reality, we've seen in practice that even within a particular case, the scope of those claims can evolve. I actually wrote a case note during law school about how even a patent, once it issues, that claim scope is not fixed. Because through continued prosecution, statements that are made in later prosecution can actually change the scope of that patent grant. So to suggest that it's somehow a finite piece of property with a defined finite scope really is a fiction. Now, Judge Plager, he would prefer to deal with the issue as one of indefiniteness. He would say, why do we have to try to resolve these impossible questions of determining claim scope when when in reality the scope is vague and indefinite. And this famous statement that Plager made was that language through which claims are expressed uses a nose of wax. It's used as a nose of wax by the court to achieve an outcome it desires, but it's also used as litigants use it to game the system throughout the case. They fight the Markman process during a case and fight the duty to assign a bright line meaning to the scope of the claim. So the way we do claim construction, usually by custom or by local rules that are being increasingly adopted in districts, is that we construe claims in a vacuum. We're not supposed to. The judge is not supposed to look to the accused product at all in figuring out where the metes and bounds of the claim are. But yet, the purpose of construing claims is ultimately to determine whether the accused product falls within or without that claim scope. So in theory, we say there's a bright line between where claim construction occurs and where infringement occurs. One side is clearly the court's role, one side is clearly the jury's role. The reality in the way that it often is litigated is that this line shifts. It's litigants avoid the process of claim construction in a manner of trying to, rather than making infringement a question of law, a question of fact. Now, it's interesting to comment on the Fifth Circuit's view on whether we should be looking at the accused product at the time we construe claims. A common practice is for parties to litigate claim construction, and once the court rules on claim construction, to stipulate to a finding of non-infringement, and then send that up, provide a means for appeal directly to the Federal Circuit, since we don't allow interlocutory appeals of claim construction. Well, this case was interesting because this case and several other cases, the Federal Circuit is upset when they have to rule on claim construction in the abstract without having the context of the accused product to assess that process. But yet, that's what district judges do all the time. District judges do Markman early in the case, usually before there's been little discovery into the accused products. And the law, as traditionally said, you construe claims with a blind eye to how the accused products operate. Now, the Federal Circuit is shifting away from that, saying, well, you can consider the context of the accused products. And it's really unclear the extent to which claim construction and infringement should begin to be done at the same time and collapse on each other. Everyone's familiar with the claim construction framework, that claim construction is a pure question of law. And we rely on this premise that there is a pure, legal, correct claim construction. It's a pure matter of law, and the claim construction process searches for this. But yet, the Federal Circuit provides relatively little guidance on the proper procedure to use in engaging in the claim construction process. So it's been left to litigants and the courts to figure out a sensible way to conduct claim construction. The Northern District of California was one of the first courts to forge local patent rules. Judge Ward in the Eastern District of Texas has also led the charge, and increasingly over time we see more and more district courts adopting these. Now, there are several options where we can do claim construction. We can do it early in the case, before there's been much discovery done. Parties didn't like this. It's efficient, but it doesn't allow the district court to look at the context of the accused process. You could also do it at the time of summary judgment motions and wait until there's actually a controversy as to how that claim scope is applied to the accused products. And then another option is you could just do it at trial in the context of jury instructions. Judges also sometimes do it purely on a paper record. They also do it via a hearing. There's somewhat inconsistent law in how courts deal with parties' attempts to change their claim constructions. Judges usually will find that a party is a stock and will let them adjust their claim construction over time. But in reality, the judge's duty to perform claim construction as a matter of law continues throughout the entire case. It's a rolling duty of claim construction. An increasingly common strategy, especially among non-practicing entities, so-called patent trolls, is to seek uncertainty during the claim construction process. Not necessarily dread, but uncertainty. Rather than seeking an affirmative construction that expands the scope of the claim, they choose to merely punt and say no construction is necessary. Then when they're confronted with the accused infringer's construction, all they do is say, well, that construction is wrong. So, in doing so, they fight attempts to perform work, and they seek to shift the dispute from a legal question of claim construction to a factual question of infringement. It's surprising that usually once the court issues its market order, it's the court's law of the case, and litigants are usually hesitant to go back and ask for reconsideration, that even if there may be latent ambiguities that exist in that construction. There's competing standards at work here, and what we're telling the district judge's role is. We tell them that they're supposed to assign a fixed, unambiguous, legally operative meaning to the claim. And when the parties raise an actual dispute regarding the proper scope of the claim, the court, not the jury, must resolve that dispute. But yet then we say that there is a theoretical limit to which you can continue to further construe the claim. Simply because the process of claim construction might not resolve the infringement inquiry doesn't mean the court, under the rubric of claim construction, can continue to give the claim whatever additional precision or specificity is necessary to facilitate a comparison between the claim and the accused product. Rather, after the court has defined the claim with whatever specificity and precision is warranted by the language of the claim and the evidence bearing on the proper construction, the task of determining whether the construed claim reads on the accused product is for the finder of fact. I think it's very common in practice that we want to resolve disputes through claim construction rather than recognizing that the claim construction inquiry can't always solve the problem, and that it does become a question of fact in terms of how the claim construction applies to the accused products. It's really interesting, during the Unilog appeal, Microsoft actually argued during the appeal that the infringement determination should be reviewed de novo. A factual question of infringement should be reviewed de novo. And the Federal Circuit had to clarify and say, well, hang on a second, just because the claim construction was not disputed and the accused product operation was not disputed, there was still a factual question in terms of how that accused product, or in terms of how that undisputed claim construction applies to the factual operation of that accused product. Now, O2 Micro was a decision where the Federal Circuit was confronted with what it perceived to be as judge, specifically Judge Ward of the Eastern District of Texas, punting on his legal obligation to construe the claim as a matter of law to the jury. And the patentee, as has become a common strategy, said that only if could be accorded its plain and ordinary meaning. The accused infringer said, no, we need to assign a more specific meaning to only if that doesn't allow for exceptions. Judge Ward said, I'm just going to assign only if it's plain and ordinary meaning because I think lay people can understand what those two simple words mean. Well, the Federal Circuit said this violated Markman. When the parties raised an actual dispute regarding the proper scope of the claims, the court, not the jury, must resolve that dispute. But we recognize that the district courts are not and should not be required to construe every limitation present in a patent to certain claims. I put this up not for your reading pleasure, to show you what the parties' dispute in this case was. This massive claim dispute was over those two words, and it was error to suggest that a jury could assign plain and ordinary meaning to only it. O2 Micro makes an interesting distinction. It says that the district court failed to resolve. It said that they decided to only have to use no construction because the term has a well-understood definition. The district court failed to resolve the parties' dispute because the parties' dispute is not the meaning of the words themselves, but the scope that should be encompassed by this claim language. They drew this distinction between meaning of words and claim scope. What it's getting at is it's interesting. Markman was talking about the interpretation of or meaning of words. Markman wasn't necessarily dealing with the notion of claim scope per se. At some point, the process of claim construction becomes merely assessing hypothetical questions of infringement. After O2 Micro, in a case in the Eastern District of Texas, the parties actually submitted to the court a series of 10 or so true-false questions, trying to put a fine point on what a particular claim element meant. And the judge was disturbed by this process, but found that it had a duty to construe the claims as a matter of law. But at some point, are we crossing the line between where claim construction ends and infringement begins? Professors Burke and Lemley published a really interesting piece in 2005 about how the Federal Circuit doesn't provide rules or guidelines for defining the quanta of text that are to be construed. Are we to pick out single words for construction, or are we to construe broad elements in a claim? And there really aren't any guidelines over this, and this is something we argue about during the claim construction process. We argue about whether we should construe this word in isolation or in broader context of a bigger element, and it actually can make a strategic difference. Professor Lemley suggests in his paper that defining elements more broadly tends to allow for broader claim scope, whereas looking at isolated terms tends to make a more narrow claim scope. So, what is the proper use of claim construction? Should it be defining meaning of words or terms, such as technical words or words that were used to obtain the patent, or should it be used to receive initial advisory opinions from the court on the parties' potential theories of infringement and non-infringement? The possible message that O2 Micro sent was that the no construction necessary or plain ordinary meaning approach should be disfavored, and that infringement questions should be decided more through the process of claim construction in terms of hypothetical infringement as a question of scope rather than meaning. The final, most important piece is that O2 Micro can be used by parties as a sort of hammer instruction to tell the court that there is some kind of underlying scope dispute that is a question of claim construction, not infringement, to motivate the court to further construe the claim. And in further construing the claim, the court sort of passes beyond goes too far, and then either improperly broadens or improperly narrows the claim scope. The example I have of that case Right, and I call, Professor Lemley has called this process meta-construction. It's construing the construction. It happens all the time. We get this initial advisory opinion as to the claim construction of an element. Then we squabble about the words inside that construction and what those words mean and what meaning they should be assigned. But oftentimes, those latent ambiguities continue to persist in the claim construction, and we're at trial arguing about the meaning of the claim construction. In the pressure products case that the Fifth Circuit decided this past year is an example where the district court felt it was motivated by O2 Micro to essentially resolve a question of infringement as a matter of claim construction. The magistrate judge had construed the term score line as one or more lines, and the district judge noticed that the defendant's trial strategy was to distinguish its slits from the construed line. The district judge said, well, I think there's a fundamental scope question here, so the judge modifies the claim construction from score line to a construction that expressly includes slits. Well, it was held that the district court erred. It improperly broadened the claim scope, reversed and re-adopted the magistrate's original construction, and remanded the case. So we see O2 Micro's command can actually cause district judges to go too far in crossing the line from claim construction into infringement. Now, the motivation behind O2 Micro could be this, is that in a recent study that just came out last month, it was an empirical analysis that some lawyers at Finnegan did in terms of district court claim construction decisions. There have been tons of enlightening empirical analysis done on claim construction at the Federal Circuit, but not as much at the district court level in terms of what are the best strategies to employ in convincing the district judge to adopt your claim construction during Markman. And this statistic is interesting. When the patentee argues no construction is necessary, it's actually a pretty successful tactic. 38.5% of the time, the court agrees and rules no construction is necessary. And even when it doesn't, it adopts the patentee's alternative construction. The defendants prevails only 9.3% of the time in that situation. Now, the important point to know, though, is that the statistics are heavily skewed based on the fact the Eastern District of Texas is the district that's rendering more district court Markman decisions than any other district. And as we know, the O2 Micro case originated from the Eastern District of Texas and its practice of saying no construction was necessary. So in surveying a series of recent district court cases and how O2 Micro is being used and how it's causing judges to behave differently in the claim construction concept, it's causing them to revisit claim construction at various stages of the case. Parties use O2 Micro to tell the judge, look, you need to go farther in construing this claim to a point where it starts to entrench upon the infringement inquiry. And you can see here, the court says that the court sees that there's a scope dispute on the term reverses and seeks to further construe it. It says when parties dispute the meaning of familiar words or phrases in patent claims, the court must discern the inventor's intended meaning. The Eastern District of Texas is still frequently adopting a no construction necessary approach, but now their Markman orders have the standard lengthy discussion of O2 Micro and the boilerplate to explain how they're considering O2 Micro's command to construe the claim. And they put now an express statement that says the court has resolved the party's claim scope dispute by refusing to construe the claim and will not further define the term. So O2 micro is being used as a hammer to force issues of infringement into the claim construction side of the dispute. So the choices for each side are this. It's the patentee can attempt to obtain an express broad claim construction to establish infringement, such as a matter of law, but they risk having that broad construction expressly rejected. Avoid framing the issue as claim construction, say no claim construction is necessary, or attempt to leave it vague, and simply argue the other side's construction is wrong using the negative canons of claim construction, forcing it into an infringement question of fact. The accused infringer, on the other hand, can attempt to frame the non-infringement as a pure legal matter of claim construction. The problem, though, is if their proper constructions are rejected, they would be foreclosed from attempting to re-advance these theories through the process of a factual question of infringement. But doing so preserves the claim construction issue for de novo review in the Federal Circuit, which is an important strategic consideration. Or they can go along with the patentee's decision to not construe the term. If the parties both agree to not construe, then that question goes to the fact finder, to the jury, as a matter of infringement. But then the problem is that once you do that, you'll waive the ability to raise that as a claim construction issue on appeal if it wasn't properly raised in the context of claim construction at the district court. That's all I have. Thank you.
Good afternoon, and thank you for staying for the last presentation. So Chris spoke to you about uncertainty in patent law jurisprudence. Jason persuasively amplified the presence of uncertainty in the law. What I want to talk about is uncertainty in an area of technology and how that sort of has a feedback loop back into patent law jurisprudence. And so, many of you know, in patent law, there's this doctrine of unpredictable arts, meaning there's some areas, historically the chemical arts, biotechnical arts, where the courts have said these are very unpredictable areas, so that's going to mean something for us, particularly for the enablement doctrine, this doctrine where we measure the goodness or the sufficiency of disclosure you put in the patent application. And of course, unpredictability can influence other things as well, most notably obviousness. So what I want to look at is whether we might want to consider having unpredictability in the area of the software arts, an area where it's not really ever been applied. That's sort of a prescriptive, normative way to say it. Maybe we should do this to alter the law a little bit. Let me unpack that, and then I'll go through the argument. And in unpacking that, I'll sort of give you the bottom line points. So first, 4 reasons why we should care about this. First of all, if we don't have unpredictability influencing the law at all in the software arts, then we might just want to know why, or think about why. Number 2, if we don't have it, we might want to say maybe we want to have it, my prescriptive point. Number 3, this question might be part of a more general inquiry if you're going to think about the quality of disclosure for software patents, for computer implemented inventions. And And then number 4, it also might be part of an argument about maybe changing the level of disclosure required for software applications. So there's 4 reasons why you might care about this. 4 things I think this argument is presented over the next 16 overheads, 4 things it might say about patent law. Number 1, I'm not so sure patent law really understands what it means when it says something's unpredictable. Number 2, we've had what I call step changes in particularly the eligible subject matter area. This is a State Street case, and then other areas in patent law never sort of responded, particularly the disclosure sufficiency documents. Number 3, we've got a specialized court that's supposed to sort of get the hang of different areas of technology. But if we should be looking at unpredictability in information technology, the specialized court didn't really do a good job of analogizing from chemical or biotech area into IT and information technology. And the 4th thing I think is that hindsight probably is a big explanatory factor as why we don't have uncertainty as a doctrine in information technology. It's really hard for me to remember what a computer was like in 1994. And this area of technology moves really fast, and so hindsight might be a reason why we have what we have. So to go through this, I want to note that I first was involved with the patent system when I worked in software for 9 years in Kansas City from 1987 to 96. And around 93, we got involved in applying for software on applying for a patent on some software long before I went to law school. And so my very first exposure to the patent system as an artisan at the time, I was always sort of skeptical of the level of disclosure, the quality of it in software patents. Then years later when I read the Policy Levers paper by Professors Lumley and Burke, I sort of saw this remark about how the Federal Circuit and the courts really hadn't thought of the posita, the person of ordinary skill, as someone who required much in the area of disclosure. So the broader point of this article was the courts should manipulate various doctrines to attune patent law to competition conditions in a particular industry. There was 8 or 9 doctrines that was discussed. It might be that unpredictability in the software arts could be a micro lever as to patent law. So we've got 5 doctrines that might drive you to put greater or more information, more disclosure into your patent application. And they're displayed here for us. And for this audience, I'm not going to spend a lot of time on them. We know we have means plus function limitations. It can also be one of those 5 doctrines. Let's just focus on overhead 6. And these overheads, by the way, if you want them, I'm happy to send them. There's paper copies up front. What I really want to think about is, what's the push by patent law? How much of an incentive or requirement legally do you have to put more disclosure into your patent applications? And sort of the bottom line answer is, as the source code, basically none, and occasionally in a few places in the doctrines we find suggestions where you might want to have well-specified algorithm. So we focus for a moment on the model or deposit column on the far right. 2 points here. If I'm analogizing to chemical or biotech areas, their models and deposits are explicit ways to meet both enablement and written description. Put this material, this genetic matter somewhere where you can go get it. So someone can enable the claims. The material lets you have a way to make and use what's claimed without undue experimentation. The second point is we've never required such a thing for software. We had models a long time ago in patent law. We filled up a great big building in Washington, D.C. That was not practical. But in the software arts, you could actually think more realistically about even having things like models or deposits, little virtual environments where there was such a thing deposited. So let's just take a quick look at this. Not necessary for this audience for a lot of time. Hypothetical claim to a software system of email or messaging firewall. It might be broad or perhaps more narrow in the claim language, but just for those who haven't seen it. I've apparently locked up the computer. And I even tried this before. All this is a Yeah, but it's actually locked now. We'll go back and forth.
Right, it's just fascinating.
Just like claims, you have to use words.
There we go. That's fine. I'll make this one. So, Thank you. Appreciate that. So, I'm sure this wasn't worth what we just went through. However, since this is the most exciting part of the whole day, I simply want to show us, for the few of you who haven't seen, the sort of block diagrams that suffices for the typical disclosure in a software patent application. And as a one-time artist in an area, I look at these and I say, okay, incredibly broad but entirely typical. Eventually you get to some words that amplify the various block diagrams. The words add a little but not a lot. And then eventually we get down around page 14 to the actual claims of this 16-page patent. So the the point of all that is to let us think about, just for a moment, here's the disclosure. This is a model of enablement. And the disclosures of 16 pages we just looked at. It rides on top of the post-CEDAS knowledge. And the structural difference that we find between enablement as a disclosure sufficiency measuring doctrine versus written description, the structural difference is this undue experimentation proviso. So let's just sort of remind ourselves one more time. The claim is enabled if you provide sufficient disclosure so the artisan can make and use the claimed invention without undue experimentation. How much is undue? Well, 5 experiments, 50, 500, it depends. How do we measure how much experimentation would be an undue amount? Patent law has this incredibly precise test called the Wands factors. And the Wands factors are here for us. And I mostly care about, for purposes of this argument, the last two, the predictability or unpredictability of the art and the breadth of the claims. Now let's just note that this notion of providing disclosure is harder early in a technology, the pioneer-inventor problem, and that is something I think that's involved here in my initial remark in thinking about how hindsight kind of influenced whether predictability or unpredictability is applied at all in the software information technology arts. Let's remind ourselves here as well, unpredictability can influence the obviousness inquiry. Make sure we remind ourselves of that logic. The more that the area is unpredictable, the more a court should maybe think that the claim is not obvious because it's in a tough area, that the technological advance was enough to warrant issuing the patent claim. So this overhead 12 is in some ways the core of my discussion because I want to look at a typical or one possible way to model software development. This is time on the horizontal axis. Our vertical axis is effort over time. And curves B and C is what I call to your attention, where curve B is, curve B is basically that design information. The 16 pages I showed you is the effort it took to write the design information, the patent specification, at least design information as to the heart of the invention and enough to build a prototype. Prototype is curve C. And so what would an unenabled invention look like? An unenabled invention might look like, imagine curve C being 10 times as high where it goes off the top of the PowerPoint. That would mean with the information you've given for the design, you have made it way too difficult, or way too much effort required to actually build and implement the prototype. The other thing this model lets us think about for a moment is curve D. Patent law, in terms of general disclosure doctrines, doesn't make you give the information to have to productize, to manufacture to scale. And so in thinking about unpredictability, it's the unpredictability that might happen here at curve C that would properly influence the wants factors in enablement for information technology. It also lets us make another observation, about curve D. In many inventions, there's a lot of self-disclosing information when the invention goes into the stream of commerce. Obviously, the patent application itself, when it publishes, has lots of information in it. But software is sort of a unique case because it's maybe the strongest case of keeping lots of information secret when you distribute proprietary software, because you distribute executable object code and you keep the source code secret. So that part is a part of this general discussion for disclosure with software. So we all know that software isn't perfect. We've all had software failures of our own, and I can sort of call to a variety of examples about, different programming languages that are more or less determinate, different operating environments that have rates of failure that are different. Let me just sort of make up one example. Let's say in Windows 3.1, which was the recited operating environment for some claimed invention back in the 90s, that in Windows 3.1 there was a set of software objects, and all the programmers who used them knew they were very fragile, very rickety, full of bugs, and the claimed process was something that would only be done on Windows 3.1. You could have, as part of the paper argues, you could have niches, areas within IT where you have unpredictability to perhaps the same degree you have it in the other areas of technology. A few more sort of statements and evidence to that from a computer scientist. There's also a big thread of literature in computer science about how they constantly say, well, it's software engineering, but yet it's not as good as mechanical or electrical engineering in terms of reliability and repeatability of results in as many niches within the area of technology. Here is the step change in patent law I referred to earlier. We had the State Street case. All of a sudden we have business methods. We go through this process with Bilski to where now we're back to having business methods. And over this sort of 15-year period, we definitely have, the plausibility, possibility of much more abstract claims for software-implemented inventions, and never really any strong adjustment in the disclosure doctrines resulting from that. So, should we have unpredictability as a doctrine that holds some sway in the information technology area? It depends in part on what patent law means by unpredictability. If it's something that comes from nature, if all that doctrine ever was for was an area of nature, we don't understand yet in nature how this works, then it's maybe not so applicable. If it's sort of attuned to other values, it might make more sense. Because in software, it's not so much unpredictable behavior from nature, but from the lower layers of software. Software is a layered enterprise, and you're on top of human scaffolding with the stuff you're building for your current implementation. So if the values for enablement and thus unpredictability are claims scope and sufficiency of disclosure, maybe there's a greater place for this. And I'm thinking about maybe a sliding scale for suggesting unpredictability with claim abstractness. Now I have one more overhead to finish off this talk. Now, this has nothing to do with patent law. And neither the left or the right up there, that's not me. So I want to indulge you for just a minute if I can and have an Oscar moment, like at the Oscars, the Academy Awards ceremony. Dennis mentioned I'm from Jefferson City, Missouri. My parents, who are not lawyers, came up here this afternoon to watch this presentation. And of course, at the break, my dad told me he really was here to see Mark Lemley. So I'll never have a chance to do this again publicly, so thank you for letting me take a minute or two just to say to Louis and Naomi Vedder, I'm just so glad that I'm your child and you guys are my parents, and thank you for all you've given me. Thanks for coming up here today to watch the wonderful afternoon of patent law, and I love you guys very much. And that's my presentation.
So we have time for exactly 2 questions. If anyone has. Yes, sir.
Question for President Holman. You mentioned that Congress needs to be better at avoiding retroactive laws and needs to take a prospective approach. Do you think Congress is really that much smarter or better at the job, or are they just afraid of takings claims if they go around invalidating whole classes of patents?
I don't know if they're smarter or better. I just say that they can. I'm just thinking out loud here, but the whole presentation. But I think there is a real problem when the courts do this, when they apply these laws retroactively. And so the gene patent is a good example where maybe gene patents are not good, but we've got a lot of investment based on the idea that they were. We've been allowed for 30 years. I don't know how the courts are going to be in a position where they can say, okay, from now on we're not going to have gene patents, but we're going to keep them enforced as we have before. That's the kind of thing that Congress has done, whether it's because of these laws or for whatever reason.
And they have a system in place where they regularly do that. Sometimes they choose not to, but those are the policy reasons. And Mark, we'll let you, right, since you're the reason why the Vedders came. Mr. Patrick.
Okay, so thank you, Mark. So this is for Chris also, and so it's one question. It's going to sound like 2 questions. So the first part is really. So it sounded to me like you sort of start off. It wasn't really your position, but it sounds like arbitrage or somebody saying something along the lines of pharmaceutical companies aren't doing R&D to the extent that they have in the past because of uncertainty in the patent law.
He did.
So that's the first part of the question, right? So
what's the question?
So the second part of the question is, the rest of the first part of the question is, based on your experience in this industry, how credible is that statement, right? Just in terms of the appearance of it. And then secondly, is the second part of the one question is, in response to you got a question just a second ago, but the idea that the Federal Circuit should be making policy. And maybe they're not that good at it. If that's true, I mean, how much of some of the examples that you showed us are just, they're just applications that some people sort of don't agree with, right? And so I guess the question would be, how specific do you think the Federal Circuit can make the law in this area before it runs afoul of either the statutory guidance or at least the control that say that PROCETA is supposed to have over the doctrine?
Okay. So the first question was, based on my experience, is Armitage's statement accurate?
Yeah.
I don't know. My experience as a scientist was just my own. And I wasn't involved in the high-level decisions of what to move forward on. But I think we can talk to, I do know a lot of people in the pharmaceutical industry, and they will say that they're not going to invest in trying to take an early-stage product to the market unless they think they've got a pretty good shot at having it. It just makes sense. If you're rational, it's going to make a difference to you if you think you're going to be able to likely to get a return on your investment. Okay? And so for that, the second example I was going to give was a compound where they got the patent on the compound in 1982. It wasn't until 12 years later that they actually figured out what it was going to be good for. It was actually could treat ADHD. Okay? At that point, they had 5 years left when they were just going into the clinical trials. They got a patent on using it in the treatment of ADHD. Ultimately, that was invalidated after they were on the market for a very short time. Why? Because they hadn't submitted data, okay, with their patent application, okay? But there is no animal or cell-based model for ADHD, so they had to have human clinical trial data. And so what they did is they got FDA approval to start human clinical trials. They started those trials, and they filed a patent application early. For one reason, because the prior art could be accumulating. 10 years later, we have a decision where the Federal Circuit says human clinical FDA trials is a public use that creates a 102B statutory bar. So you're in that kind of situation, and you're making these kind of decisions. I think if they only had their composition of matter patent, we basically would say they would have no patent protection for their drug that you develop as an ADHD drug. I don't think they would have been able to invest in developing it as an ADHD drug. Okay, so that's part one. Part two, so part two is,
So part two is how specific, in view of these things, right, these applications like you just described, right, how specific can the courts really make the law before it really can't make it that specific anymore, particularly maybe in the area of like obviousness or enablement or written description?
yeah, I mean, I think I kind of tend to like more the standards logic. I think the problem with a lot of these bright line rules is that they're applied. Bethesda is a good example. It's obvious it's not no patenting. They make these bright line rules without any sufficient consideration of these investment back expectations that are applied retroactively. I tend to think that when they have these vague standards, the right outcome is what they get a lot of times. I'll say that Lilly written description, there is no real coherent criteria for what it means. But if you look at the outcomes, I think they're correct. Area v. Lilly, I think that a lot of people would agree that there was problems with that, with those patents. And so, yeah, I think the vague standards are okay. The court is doing a pretty good job usually with those. In terms of your question, I'm not sure I even have an answer to it. I thought of that in terms of how specific they can get.
I think that's a good place to stop because it leaves us open for the next conference.